Okay, well, welcome everyone to the First Place Exchange. We're excited to have you all here on this beautiful Saturday morning. Our first webinar is our Education Law series, and um, thanks all for being here. So, the Place Exchange is a forum for educators, families, and communities. This first education law webinar is hosted by the UW School of Education, Department of Educational Leadership and Policy Analysis, and also the Professional Learning and Community Education Office, or known as PLACE. A special thank you to the School of Education Dean's Office and the Mary T. Kellner Teacher Education Center for their sponsorship, and for all of you for joining us today. You can, throughout these slides, there will be some links for further information. So we invite you to share more about the Place Exchange, the recording of this session, and sign up to learn more about what Place offers. And you can see the link to our YouTube channel at the bottom there. Before we jump in, we want to mention that this is part of a series of education law webinars. We have two upcoming webinars in this series, the First Amendment Rights for Students on Saturday, February 7, and Understanding Special Education Law, Exploring What's Old and What's New on March 7th. You can sign up with a QR code there or with the link below. Help us spread the word about the Place Exchange. Before we jump in, thank you for joining us. We have some logistics to cover. So all of you were muted upon entry. You can direct any questions that you have to Sandra or myself. We're moderating the session. Please don't put questions directly to Suzanne as she'll be speaking. So we'll monitor those questions via the chat. There will be a Q&A section at the end, about 20 minutes, where Suzanne will answer questions that you have. That portion will be recorded just for our note-taking purposes, but will not be part of the posted live recording or the posted recording following the event. The lecture will be about 55 minutes. Please keep questions broad and anonymous by not mentioning names, places of employment, and specific questions that only pertain to you. Closed captioning and AI transcripts have both been enabled for accessibility, and slides will be shared at the end of the session. So, welcome to the first session in the Place Exchange series that brings you timely topics, trusted voices, and transformative conversations with UW experts from the School of Education. Thanks for being here. Today, we're featuring Suzanne Eckes, who will help us consider and understand important legal developments for educators. This is the first of 3 sessions. We are privileged to have her lead. And with that, I think we can turn it over to Suzanne.
Thank you so much, Stephanie, for that introduction, and thanks to the entire staff and faculty at Place, and as Stephanie said, to the School of Education and the Mary T. Kellner group for supporting what we're doing here today, which, as you'll see, I'm really passionate about this particular topic around education legal issues. So welcome, welcome, welcome. I know it's not early, bright and early on a Saturday morning. May not be the most exciting place to be, but I'll do my best to make it interesting. And I was really happy to see, I could see who was entering. So some of my former ALPA students and MISPE students and many new people. So I'm really happy that you joined us today. So again, my name is Suzanne Eckes. I am a faculty member in the Educational Leadership and Policy Analysis Department. I'm also an affiliate at the UW Law School, and I teach several different courses around legal issues that impact teachers, educators in general, school leaders, principals, superintendents, special ed directors. So I could talk about this topic all day long. Today, we're focusing on new legal developments for educators, as Stephanie noted. So just very briefly, who is our target audience? So everyone is welcome, if whether you're a faculty member, a lawyer, a parent, a high school student, you work in a K-12 public school, you are all welcome. The target audience, when I made the PowerPoint, who I had in mind was this is very intro level, maybe targeted more toward teachers, school social workers, school psychologists, new teachers, teachers who haven't had a school law course, or even a principal who had a school law course 10 years ago and needs some updates. So it's a very intro level. You don't need to have any background in law or really education to follow what we're talking about today. And why did we develop this three-part series? As Stephanie pointed out, this is our first one on new developments, and we have another one coming up that I will lead on student expression, student speech rights, First Amendment rights in schools, and then the wonderful longtime professor in ELPA, Julie Mead, will lead the one on special education law in March. So why did we develop these three? Well, I'm a former K-12 public high school teacher. I taught high school French. And then after that, I was a practicing attorney. And I saw in both of those roles how education law and just a basic understanding, you don't need to be an expert, but a basic understanding of basic legal literacy can help you advocate for yourself as an educator, advocate for your students, their families, the community, others that you work with, and also at the same time help you and the school avoid costly litigation. Again, you can't avoid everything, but with a basic understanding, baseline legal literacy can go a long way. And so that is one of the reasons we developed this webinar series. Also, there was an interesting study that I read in the Harvard Education Review. This was a few years ago now, where the authors found that a lot of educators, a lot of teachers get their legal advice from their principals. And that's because many pre-service teacher education programs around the country do not have an education law course or even a special education law course in their scope and sequence of courses. That's not the case everywhere. We have one at UW-Madison, there's one at Indiana. There are some exceptions, but for the most part, teachers typically don't get an education law course, a 3-credit course, as part of their professional development or their course scope and sequence. Now, principals and superintendents, it's often part of the licensure sequence. So that is why I'm so passionate about this, to just bring some new information to those who maybe have had no background, but they read about it a lot in the news. Just this morning, I read in our local paper in Madison about a legal issue around allegedly failing to report child abuse. And as I read the article, I said, oh, there's some really interesting, maybe some Title IX issues that arise here as well. So every day when I open the news, whether it's the local news or the national news, I see things that I could bring to class that day, because there are so many interesting legal developments that happen on a daily basis. It's just really hard to keep up. Again, who is sponsoring this presentation? Stephanie mentioned already, but thank you again to the UW-Madison School of Education, the Department of Educational Leadership and Policy Analysis, and to PLACE, the Mary T. Kellner Foundation, and also for the outreach development funds from the School of Education. So thank you, thank you. You'll see at the end of this slide right here, I have nothing in this presentation should be considered legal advice. This is a non-commercial presentation for education purposes only. If you do need legal advice or assistance and you're an educator, you should definitely consult with an attorney. I'm an attorney, but I'm not giving legal advice on this particular webinar today. So some of the highlights that we're going to try to cover in this short time span. You'll see a list of hopefully topics that you find interesting. And as you look at this list, you may say to yourself, why is there nothing about disability law or special education? Why is there nothing about what students can say inside and outside the classroom on social media? What about bullying and harassment? Well, what about it? Yes, those are huge issues as well. And that's why our next two sessions will cover those in depth. The student expression one intersects with bullying and harassment and social media. So if you're interested, be sure to register for those upcoming sessions. But today we'll focus just very briefly on some of the new developments around curricular related challenges. There's a new US Supreme Court case this last year that I think many of you will find interesting if you don't already know about it. I'll spend a tiny bit of time on teachers' expression rights, just because it's been in the news so much lately. Teachers posting things about political issues on Facebook and then maybe getting disciplined or even fired. And relatedly, somewhat, is teacher out of school conduct or public employee out of school conduct. So I'll cover a few scenarios, real life scenarios there as well. And then there are a few evolving issues around church state and religion in schools, mainly in the past 3-4 years. And so if you haven't had a school law course ever, or if you are a principal and you took it 10 years ago, you may not know about some of these new issues that have arisen that have really changed the landscape around religion in schools. And I'll talk briefly about student injury, discipline, and other evolving issues, hopefully around privacy, AI, if we have time, and we should be. I have my cell phone out, and Stephanie said she'll keep me on track with time and give me some reminders. But there's a lot to talk about. I could teach a class, just a whole semester class on each one of these bullets. But we're going to be spending, 5 to 10 minutes on each of these bullets. And then, as Stephanie mentioned, we'll be saving about 20 minutes in the end for questions. So let's begin discussing some new evolving issues around curricula. So you see this different controversies. It's in the news quite a bit if you follow these issues, or if you're working in a K-12 public school, some of these topics you may have seen firsthand, where parents, they're either challenging an aspect of the curriculum, they don't want something covered at all, or more frequently, they request that their children get to opt out of certain parts of the curriculum. Imagine this, whether you're a teacher or not, you can see this happening. I get calls all the time about these types of questions, so many that I don't even have time to email everybody back around this specific topic, of teachers who email me, oh, I teach 5th grade and we're reading Harry Potter, and a couple of parents said that that's witchcraft and they want their child to be opted out, or they want notice when we're discussing climate change. We believe climate change is a hoax, whatever it may be. And so they request, whether it's, challenging aspects of the curriculum or asking that their child, is able to opt out from, a one-day lesson to a whole month part of the curriculum. So just generally speaking, and again, this is just a very broad overview of some of the developing legal issues, it's much more difficult for a parent to challenge a whole curriculum because, of course, the state and local school district controls the curriculum. But there have been some recent developments that I'm really excited to talk about today related to parental opt-outs. As of last summer, the legal landscape has really changed as a result of a US Supreme Court decision. In this case, from 2025, parents wanted to opt their children out of LGBTQ plus inclusive storybooks that were part of the curriculum in an elementary school. So initially, the school leaders would permit opt-outs and teachers would permit opt-outs. But then it became kind of cumbersome, where too many people were asking for the opt-out, and teachers were really burdened with, this person wants this covered during this week, and this person wants this covered. And it just became a really tall order for teachers to allow all these different individual opt-outs with different requests, with different things that their child may do during this storybook time. So the parents in their lawsuit alleged that they had this fundamental right to direct both the religious and educational upbringing of their children. You see these 14th Amendment claims. I have the right to control the upbringing of my child. I have the right to raise my child is the way I see fit. Or you see First Amendment challenges of this violates our sincerely held religious beliefs. You're violating our right to freely exercise our religion. Our religious beliefs conflict with something that you're doing within the curriculum. The school officials in this particular case, they argued that this was a neutral and general applicable policy. And, from reading more into this case, also they looked at previous circuit court cases where some of these circuit court cases, they weren't all uniform, but there was definitely a general trend in some of the earlier federal court cases where the courts would say things like, no, this is a really important part of the curriculum. You can teach what you want to teach at home, but we don't have to allow all, opt-outs in all situations. If you want to teach your child on the weekend at home that the earth is flat rather than round, you can do that, but that's part of our curriculum and, we're not even allow you to opt out. But from teaching, being a member of the faculty for many years and having been a high school teacher, I know that many school officials, whether it's school policy or not, they'll allow the kid to opt out just because sometimes it's much easier to do that. But now we have a recent ruling from the U.S. Supreme Court that gives us even more guidance on this particular topic. So even though the lower courts ruled in favor of the school and, supported the LGBTQ plus inclusive storybooks, one of them on the side that was challenged was a book about Pride Puppy. I believe it's about a puppy getting lost at a Pride Parade. So the lower courts, sided with the school. And then later, the U.S. Supreme Court ruled in favor of the parents. And again, I'm speaking very generally. I'm not getting into the all the complexities of the case. But you may wonder, what does this mean for me if I'm working in a K-12 school and parents ask that I opt their children out, or I'm a principal of a school? Well, I think the big picture overview is parents should be given advance notice and the right to opt out, especially when what's happening, as part of the curriculum conflicts with their sincerely held religious beliefs. Also, I think it has to be more than just mere exposure. If you want to nerd out on this case, as I do, you can go Google Mahmoud versus Taylor, and you can find all kinds of commentary from law firms and legal scholars. You can find the actual case. You'll see that the court discussed this was more than just mere exposure to the Pride Puppy. This was, really strongly expressing a viewpoint, according to the court. So I think that's one key takeaway that many of us would agree on. What not all of us commentators or ed law professors or ed law attorneys who specialize in this area maybe take different approaches to interpreting what the case means. Some interpret it kind of narrowly, and they'll say, and there's no shame in either way. We don't know. We'll see with evolving court cases as this develops. Some take a more narrow view, and they'll say, oh, just wait a second. This guy's not following educators. You don't have to do opt-outs in high school. Families, they're pacifists, so they want to opt out of any book on World War II, or they want to opt out of any book, that's related to conflict or war. No, these commentators say it's more narrow. This was elementary school. This was just LGBTQ plus storybooks. But other law firms who write really great commentaries and post them online, and educational law professors who write on this topic maybe take more of a broader approach, and they'll say, this really opened a can of worms. So now anytime part of the curriculum conflicts with a parent's sincerely held religious beliefs, and for religious beliefs, they don't want to read Harry Potter, so now I have to assign Mary Poppins is witchcraft too because she flies. But anyway, you know what I mean? That anytime there's some type of conflict, you have to give notice and allow people to allow parents to opt out. So that remains to be seen. So this doesn't mean, I want to stress this, that you need to ditch your, lesson on Harry Potter or climate change, or teaching that the earth is flat, or having LGBTQ plus inclusive storybooks in your classroom. This lawsuit wasn't about ditching the entire curriculum. The lawsuit was about giving parents notice and caregivers notice, and the ability for them to opt out. That's one of the key takeaways. So when I teach education law, the students often get really annoyed with me because they want black and white, and there's so many gray areas in education law, and it's going to play out in subsequent court decisions how different federal district courts and circuit courts are interpreting Mahmoud versus Taylor. And maybe another case, if there's a conflict between different circuit courts, they don't agree on what this means, there'll be another Supreme Court decision to clarify. But with that being said, because you're going to have access to these slides if you registered, throughout this whole presentation, because it's quick and I don't have time to get into, well, this law professor at the University of Washington said this, but this wonderful local law firm in Madison said this. I've tried to put resources on the different slides so you can go read really accessible pieces. I find these really accessible. And there's so many others. You can just Google this case and you'll find pieces in the conversation. Does a great job of making really public-facing, accessible, complicated Supreme Court cases digestible for parents and community members, teachers who have no background in education law. So I try to include different helpful resources. So we're going to switch gears a little bit. So we just focused on parents who challenge. Let's just talk about, because, when I was coming up with these topics, I asked my students from last semester, what should I cover? And they're like, here are the top areas you really need to cover. So here's one of them that they always ask about and they're very concerned about. So I'm including this one. Do teachers have First Amendment rights in the public school classroom to voice their opinions? So, imagine you're a teacher and you have a quote from the Bible or a quote from the Quran on your wall and you teach Algebra 1. Or you give your opinion in a geometry course or your French 1 course about what's happening in Venezuela. Is that part of the curriculum? Is that what you were hired to teach? Can you give your opinion in class? Do you have these First Amendment rights? Well, I will say that First Amendment rights, you don't have a lot of leeway as a K-12 public school teacher, as much as I would have as a college professor. And so I'm going to walk through some of these limitations. So, as a general rule, your administrators, school officials can censor, limit, curtail your school-sponsored expression for pedagogical reasons. They have to have a legitimate pedagogical concern. And they can also limit speech that's unrelated to your official job duties. So again, if you're teaching Algebra 1, and you have a life-size blow-up picture of Bernie Sanders in your classroom, or a quote from the Quran, or you're giving your opinion on Venezuela, well, were you hired to teach that, or were you hired to teach Algebra 1? So let's talk about that. And I've got some real-life cases. This one's a little older, but I bring it up because I used to be a teacher or a professor at Indiana University. And this happened in Bloomington, Indiana, where I was a professor. So I know this case very well. It was in the school district where my son went. So imagine this, back when the Iraq War was taking place, it was college town. There were protesters every Wednesday at our courthouse square in Bloomington, Indiana. And people would, protest the Iraq War. And they would hold signs that said, honk for peace and all sorts of different things. So there was a teacher, I believe she was 5th grade, maybe 6th grade, and she was doing a lesson on current events because she taught social studies. And she was talking about the Iraq War. And one of the students said, hey, raised a hand, do you honk for peace when you go past the courthouse square in Bloomington? And they said, yes, I honk for peace. And the teacher's contract wasn't renewed. And so the teacher sued and argued, this is violation of my First Amendment right. The teacher, and again, I'm speaking very broadly, you can go pull this case, just Google Mayer, Mayor, versus MCCSC. And I also have a resource where you can right click when we give you these slides. You can read more about it. You can read the whole case, actually kind of short. She lost at the federal district court level. And then she appealed to the Seventh Circuit Court of Appeals. And I know from registration, many of you are from teachers, educators, work in Wisconsin, DPI, whatever. So you probably know that a Seventh Circuit decision is legally binding in Wisconsin, Illinois, Indiana. So you got to pay attention to this case, even though it's older. That's why I brought this one up. And she lost her case. They said, you're hired to teach the curriculum. Teachers have been put on notice not to give their opinions in class about controversial matters. And then she appealed to the U.S. Supreme Court, and they didn't take their case. And that's not surprising because it's a really big deal, like the Mahmoud versus Taylor case I just talked about. When a case goes to the U.S. Supreme Court, it's a very big deal because they agree to hear less than 5% of the cases are even asked to hear you because there's just so many. So they did not take their case. So one of the key takeaways from this case is you don't have a ton of leeway. Even this is a little bit older case. These types of issues arise all the time. You see them in the news, different current events that maybe don't lead to litigation, but leads to a teacher getting disciplined and possibly losing their job, and they don't have $300 an hour to hire an attorney. So they're not even litigated. But the key takeaway from this case is when you're a K-12 teacher, you don't have a lot of flexibility in the classroom to give your opinion on political matters, to have that life-size picture of Bernie Sanders in the classroom, or to have, a quote from the Bible Quran in your classroom. It has to be linked to the curriculum and also be presented in more of a neutral way. Why is that? Like, why, when I was a public high school teacher, did I have fewer First Amendment rights than maybe, what I do now, what I have now as a college professor at UW-Madison? Well, when you read some of the Supreme Court cases and circuit court cases in this area, they talk a lot about that K-12 students are a captive audience with impressionable minds. So what you're saying to a fourth grader is different than what I'm saying to a graduate student or the undergraduate side teacher, juniors. They can say, Suzanne Eckes, you are full of a lot of BS, and I'm going to move on, and I'm not going to listen to you. I don't agree with what you're saying about this case, and they're able to separate what I'm saying. But imagine a fifth grader or a first grader where you're giving your opinion in a K-12 public school classroom. That's where some lines have been drawn. This idea that students, K-12 students, are a captive audience with impressionable minds. So we'll circle back to this idea of impressionable minds, captive audiences, when we talk about church-state relations as well. So that's just a very quick overview of teacher speech inside the classroom. But what about teacher speech outside of the classroom? So this is in the news all the time, right? Some of the things that have arisen. Can a teacher express their opinions at a political rally or on a political matter at the Capitol in Madison or in DC? Can a teacher post their thoughts about various matters, on social media? Can a teacher speak out against a school policy? A teacher says, I don't like that we're cutting our library or librarians in the elementary schools, or we're no longer offering foreign language, and they're writing letters to the editor, and they're voicing their concerns at school board meetings, and they're passing out flyers on the weekends. Can you do that? How much leeway for your expression do you have outside of school? You just learned inside the school, not much. Well, what about outside of the classroom? And what if you're posting on Facebook and it's a private account? Well, let's talk about some of these. Here's a recent case. If you are local and you read the newspaper, you know about this case because it's pretty recent. There was a guidance counselor from the Milwaukee area who spoke at a rally about their opposition to allowing transgender students to transition. The guidance counselor eventually lost their job. They sued and lost their case. So the teacher in the lawsuit argued all sorts of interesting points about, I'm speaking about a matter of public concern. My speech should be protected. Well, you see from the second bullet that the court found that her speech was related to a matter of public concern. It was, but the school's interest as a public employer outweighed their speech rights. The court reasoned that their speech was vulgar, belligerent, and that it was focused on attacking individuals instead of ideas. So just about this point, when I'm teaching this case or the hundreds of other cases like this in my education law courses at UW-Madison, people get really mad one way or the other, and that's fine. I'm just reporting what happened because this is legal binding case in our jurisdiction. So, as I said, we don't have a lot of time. This presentation is just about an hour long total with some questions. So you can read about this case and you can find all sorts of commentary from law firms and different legal scholars about this case online if you're interested. And I'm going to go through the legal standard as I get, in about 2 more slides, because I couldn't help talking about another current event that is local. So another Wisconsin teacher was really excited to have her students sing a song called Rainbow Land at their spring concert. This is a song, if you don't know Rainbow Land, which is sung by Dolly Parton, Miley Ray Cyrus. And in this particular district, there had been some issues in the past around maybe the district trying to prohibit pride flags in classrooms or maybe not allowing safe space stickers. Not going to get into all of that, but big picture, teacher was asked not to include this. They could sing another song that had something about maybe rainbows in it. Oh, Somewhere Over the Rainbow, I think, by Kermit Frog, but not this particular song. So the teacher, who maybe didn't have a school law course, or maybe did and thought this is a matter of public concern, the teacher posted on X, formerly known as Twitter, "My first graders are so excited to sing Rainbow Land." You can see the tweet. And, was very vocal, angry, upset. Lots of other teachers and, families supported the teacher. And, the teacher did, identify where they taught, I think the name of the school. So you can read more about this current event when we share the slides with you, if you're interested in this case. So what happened in this case? Again, the teacher was found to be speaking about a matter of public concern. They were a private citizen. So even though the tweet mentioned where they taught, they were still like, this is what you can do. Even though you're a public educator, you're still a private citizen and you're allowed to speak out on social and political matters that relate to a matter of public concern. But school districts, as you know from the guidance counselor, Milwaukee, school districts engage in this balancing act where they have to weigh the interest in workplace efficiency and First Amendment rights. And that's what they did in this instance. They found that the speech caused a disruption, and in one example is that it required police presence in the school. Here's the standard. So I want to just walk you through just very quickly. If you took my education law class, we'd spend like 4 hours on this, but I'll do 4 minutes. The first question, what's the expression made? Was it related to your official job duties? If yes, you don't have First Amendment protections. If it's not related to your official job duties, so you could see how both of those scenarios, maybe you could argue are related to their official job duties, maybe not. So that's why there's a lot of gray area. I could put this on a final exam and I give full credit both ways, as long as they supported what they said with previous case law. If the expression relates to a private grievance, it's not constitutionally protected. If the expression relates to a matter of public concern, as in both of those cases, the court found that it related to public concern, the speech is protected unless, here's the but, it impairs the teaching effectiveness, interferes with the relationship with superiors, or jeopardizes the management of the school. So it's this balancing test. So in both of the scenarios that I just talked about that are local in Wisconsin and recent, yes, they found that the speech was about a matter of public concern, but it didn't really pass this balancing test. So you can read more about this particular case here. you can see how this would play out after the murder. I made this up loosely based on some earlier things that have happened in the past few months. After the murder of a prominent progressive unelected political figure at a rally, an elementary school teacher posts the following on a private Facebook page: "I never condone murder. I can't stop thinking that this woman said super hurtful things about my community. RIP, but I shouldn't be forced to cry about it." 5 crying emojis. So imagine that someone posts this at your school. Several parents complain this teacher's expression is sensitive, callous. They should be fired. The teacher says, I'm speaking out about a matter of public concern. It's on my private Facebook page. Stay out of my personal business. Well, was this expression made pursuant to one's official job duties? Probably not. Was this speech about a private grievance? Maybe you could argue that, maybe not. Maybe it's a matter of public concern. Well, then we engage in this balancing test, as the courts did in the case involving the teacher who attended the rally in Madison, the Milwaukee counselor, and the other teacher who tweeted about Rainbow Land. So I just wanted to show you how, if you were taking my education law course, and the MISB and ELPA students who have me, they know what an apply your knowledge question is. I do these every week, and we sit and apply previous case law, to real world current scenarios. You can find more. I have a teacher speech article that I published with Charlie Russo that I have linked here, and it's a long article, but it's really easy to follow. It's on teacher speech inside and outside the classroom. You can read more. Just before we switch gears to out of school conduct, I just want to quickly say, I always have students in my classes ask me, well, what's a private grievance? A private grievance is when you're complaining about a personal matter that really doesn't link to an important issue like public safety. So like if you imagine you're a teacher, you're complaining about, I have this overcrowded classroom and it doesn't have enough wall space, so I can't put my rainbow pictures up, or I can't do this, or I can't do that. It's not really linked to a matter of public concern. That would be a private grievance, and that's typically, well, that's not covered by the First Amendment. Well, what is considered a matter of public concern? It's usually when speech relates to political, social, or other community concerns. So here's an example. A teacher attends a pro-marijuana rally, wants legalization of medical marijuana. They have an aunt who's dying of cancer, and they think medical marijuana would be a really great idea in Wisconsin. And parents see them there and say, I don't want this drug addict teaching my 3rd grader. Well, being at a marijuana rally for medical marijuana on a weekend is probably not related to your official job duties. And also with that balancing test, I would put my money on the teacher, but I've seen things go different ways. Okay, we talked about teacher speech in the classroom. We talked about teacher speech outside of the classroom. Let's talk briefly about teacher out of school conduct. This very quickly. Can we regulate what you're doing in your personal time? So imagine this. This is a real life case out of Michigan. There was a teacher who went to a bachelorette party over the weekend in the summer at the Jobby Nooner bar in Michigan, and got up on the stage with a male mannequin and performed a sexual act with the male mannequin. She was recorded. It was put on social media. She didn't even know it was recorded. She didn't even know who recorded her. Parents found out about it. She loses her job. What do we do about that situation? Well, the legal standard, or, the framework that some courts have adopted is, is there a connection back to the school with this like open and notorious conduct? People know about it because it was placed on social media. Was the teacher's conduct, this open and notorious conduct, did it negatively impact the teacher's classroom effectiveness? In this case about the teacher who went to the Jobby Nooner bar, they found, this conduct was maybe unbecoming of a teacher, but this was during your personal time during the summer, and there was not enough evidence that this really impacted their classroom in a negative way. So I just want to lay out, like, this is the standard. This is what courts use, many courts, not all. And just for you to think about this, because when I teach a lot of pre-service teachers or new teachers who are taking my class, they're also a little bit surprised about this because they're like, sorry, that's my summer vacation. I can go to a bachelorette party, or I can do what I want on my personal time. Not so much. So think about, or I shouldn't say not all the time. So think about, this framework before you get recorded unbeknownst to you and it's posted on social media. Here are just 2 other real world examples. This is true. A teacher was fired. He was an art teacher. He painted with his buttocks. He would sit in the paint and he would paint butterflies and he sold them. It was on YouTube. He's wearing Groucho Marx mask. He gets fired. Another teacher in Texas, she went to Colorado over spring break, had some marijuana laced brownies. She knew about it, posted on social media. She gets fired. In both of these cases, teacher gets job back, or the teacher, it ends in a favorable result for the teacher. I'll just quickly, briefly, because I'm running out of time, mention the Colorado case or the Texas case. The judge in Texas was like, hey, do any of you teachers go gamble in Vegas? Hey, some of that type of gambling is also illegal in Texas. Do we fire people who go to Vegas? Nope. And so we're not going to fire, according to this administrative law judge, we're not going to fire this teacher either. But I do know lots of scenarios where teachers have been fired for whether it's a DUI, whether it's not all cases with DUIs, it's case by case, domestic abuse, all sorts of different things, getting really drunk at your college homecoming. So just to be aware of that legal standard. Now, moving right along, new developments around church and state. If you took school law before 2022, you heard all about the Lemon Test and the endorsement test and the Establishment Clause. Well, the analysis has shifted. When I heard about this coach praying at a public school football game after the game, where students, according to many of the students, felt kind of compelled to pray with the coach, they felt peer pressure. I kind of thought, no, we already have two U.S. Supreme Court cases. Very broadly speaking, one said we can't have prayer at high school graduation. One says we can't have prayer at a football game over the PA system during the game. So I kind of thought, natural progression. The school will win this case. And the school allowed the prayer at first, but then they worried about being sued and the Establishment Clause concerns as a result of these earlier Supreme Court decisions at graduation prayer football game. Well, anyway, goes to the U.S. Supreme Court and they throw out the Lemon Test, if you know what that is. They throw out the endorsement test and they adopt a different standard, history and tradition of religious pluralism. The Establishment Clause should be interpreted in accordance with history and what faithfully reflects the understanding of our founding fathers. Big picture overview here is the Establishment Clause, some would argue, has maybe been put on weekend and free exercise rights are strengthened. And those who argue I have religious freedoms might be able to rely on this U.S. Supreme Court case. You can listen to a podcast from Chalk and Gavel here or a podcast on all sorts of different education law topics on Chalk and Gavel. They go over this case in depth. It's a very interesting case. So I just wanted to bring it to your attention because things have shifted around the analysis. And now we look at, what is, the history and the reflections of our founding fathers when there might be an Establishment Clause concern of like the school is coercing or endorsing religion in a public school setting. So anyway, that is an interesting, fairly newer development that some of you may not know about. This case doesn't mean you can go lead a prayer in your first grade classroom. This was after this high school football game, after the game. So again, gray area, we'll see how this plays out. Related to church-state controversies, you may have been reading, this has been in the news a lot lately, several states, and 3 states in particular have been involved in lawsuits where the states have laws, these 3 states have laws that require the 10 Commandments be posted in public school classrooms. Are these state laws constitutional? Well, in 1980, the Supreme Court said no, but we have 3 states that said, let's post them. Well, let's see where that's going to line up. Precedent says that you shouldn't be able to do that, but I imagine that they're trying to test because the Supreme Court is a little bit more friendly to, isn't as concerned as the Establishment Clause as maybe past justices and maybe takes precedent a little bit differently. Considers precedent a little differently. And so maybe they're trying to bring it up to the US Supreme Court, thinking they have a sympathetic Supreme Court that will rule in their favor. I don't know. I'm wrong a lot. We'll see. You can read more about this topic right now in the 3 states with litigation on the 10 Commandments. All 3 laws have been, last time I checked, partially blocked. So here's an article from December 2025, published in The Conversation by Charlie Russo that has links to all 3 cases, including the Supreme Court case from 1980. So really interesting, new evolving issues around church state. And Stephanie, I bet you're going to tell me I got 15 minutes left or not even. Okay, I'm on it. I'm a fast talker to begin with, so let's switch gears to student injury. There's just lots of questions around, can I be liable as a new teacher if a student in my class is injured at recess during a field trip or in the classroom? Well, let's imagine this. Mr. Hill takes their fifth grade students to the local museum. They followed school policy, had the correct number of chaperones. After the tour of the museum, Mr. Hill says, "Oh, that was so great. Everybody gets 5 minutes, the last 5 minutes to go back to your favorite exhibit and spend time looking at it and taking pictures of it. Be back here in 5 minutes." Mr. Hill knew that a few students might have problems following directions, so specifically tells Harry, Tamika, and Usha that they need to stay with the teacher if they could not handle this 5 minutes of freedom. All three students said, "I got it." Well, during the 5 minutes of unstructured time, Harry starts sliding down the staircase banister, falls, breaks a leg. You can see how this would happen at recess. They're floating around on the monkey bars. Someone falls and breaks the collarbones, flips off a swing. Harry's parents sue Mr. Hill and the school district for negligence. What do we need to think about? Well, I would think about these things. This is, very much relevant related to state law, but general picture, broad overview. Here are a few things that I talk about in class. For a parent or a plaintiff to establish negligence, you have to prove there's an injury. Well, there's an injury. Little Harry, Brooke, they're like, is there a duty? Yes, as a teacher, you have a duty to supervise the students on a school-sponsored field trip or on the playground or in your classroom. Did Mr. Hill breach their duty? Well, if I put this on a final exam, I give credit to students both ways. Some would say, yes, Mr. Hill breached their duty. The other half of the class would say, no, they didn't breach their duty. Well, as long as you back it up, you could say they breached their duty. You should know better. It's foreseeable that 5 minutes of freedom with that age of students, you could see that that could be problematic. And then causation is a little trickier. I've got a resource that you can read about causation, but I'm not going to get into all the details about cause and fact or proximate cause. But basically, we're looking at, was there a connection between the teacher breaching the duty and the injury? But you have to have all four of these elements generally to have, a negligence case brought against you. Again, helpful resource on this particular topic. Some things the court might consider: did Mr. Hill behave as a reasonably or conduct themselves as a reasonably prudent teacher would in a given situation? And, was it foreseeable that, that this accident could occur? Could this accident have been prevented? Those are some key questions that often come up in these types of lawsuits. So whenever I'm teaching about injury, my students always ask me, hey, what happens if someone injures my reputation? What if a student posts something about me on social media? That's an injury. A parent posts about me. That's an injury. What about injury to reputation? So you probably know the difference between libel and slander, defamation. Slander spoken, libel's written. Can teachers, let's say, sue students or parents for defamation? Well, yeah. So if, let's say, a parent posts something about you online that they know is like this false statement, total lie about you. I have a former student of mine where the parents and students started spreading around that they were a stripper on Thursday nights and all weekend long, and they weren't. It didn't go anywhere, but maybe this teacher could have sued for defamation, or this principal could have sued for defamation, because it has to be a false statement. It has to be made to a third party. It has to be believed to be true, and it has to damage, let's say, the educator's reputation. So those are some of the considerations about injury to reputation and under this umbrella of defamation. So I have, what is the different standard for public versus private, and why the heck do I have a picture of Johnny Depp and Amber Heard? Well, the standard is different for public and private people. If you're a teacher, you're generally considered a private person. And what I just said about the false statement made to a third party, believed to be true, damages a reputation, that's typically what we have for a private person. It's easier for a private person like a teacher to win in a defamation suit than it would be for like Johnny Depp to win in a defamation suit. Because when you're a public person, you have to show actual malice. It's governed by state law. It's a higher standard typically. So kind of related to injury, let's move into some discipline issues. When we think about discipline issues, there's all sorts of legal issues around due process rights, maybe under the 14th Amendment, Fourth Amendment, privacy rights, if you're like searching students when you're trying to discipline them. So I try to combine some things around privacy and discipline where I'm getting a lot of questions about in the last year. And when I teach the classes at UW-Madison, I just get lots of questions and people want to do their papers on this all the time, their final papers. So we know that states are taking steps to limit students' use of cell phones in classrooms and schools. They say different things. 34 states, Washington, D.C. now require school boards to develop policies addressing cell phone use. So these policies are led to increased discipline, due process issues arise, privacy issues arise around the Fourth Amendment, search and seizure. So I have a great, well, I shouldn't say great, I wrote it with Charlie Rissa. Here's an article that was published at the University of Pennsylvania Law School a couple months ago on this exact topic, and it walks you through some of the legal issues involved with this. So we talk about various legal issues in our short article, but one of the things that happens is when you have these no cell phone policies, they're all different, but like some districts might say, you can only have your cell phone before school, during lunch, or, during study hall or after school, but you can't have it during your Spanish 1 class or your English literature class. Well, you confiscate the cell phone because that's what the policy says. But what if like the lock screen's not on and you see that they're sexting, or you see they're talking about drug use or whatever it may be? And then you start scrolling through other pictures and you start scrolling through their texts. So, privacy issues arise with this. And, with Fourth Amendment, some of the big picture questions is the search reasonable? Do you have individualized suspicion to search their phones? What if the lock screen is on and you ask for it and then you start looking through all this stuff? I think that's problematic because typically we're going to ask, was the search justified at its inception? Well, it depends what the policy is. The policy probably is, your school policy probably doesn't say, hey, take their cell phone and then go through all their pictures during Spanish 1 and then read all their texts for the past 2 years. It probably doesn't say that. It probably says, take their cell phone and give it to them after school or give it back to a parent at the end of the week, whatever it says. So I would say the search probably not justified at its inception. And was the search reasonable in scope? Can you start going through all their texts, going through all their pictures, and start searching their car, searching their lockers? So, this just raises interesting issues and dilemmas that I get a lot of questions about around privacy issues, Fourth Amendment rights, locker searches, car searches, backpacks, pockets, strip searches. All we know is, there are privacy rights. You definitely, of course, have more privacy rights around a strip search, which are allowed in very unique circumstances, as I have linked here to the resource on this slide, as compared to a locker search that the school owns their lockers if you're going to search. So I want to save enough time for questions. So I'm just going to very, very briefly continue with privacy and just finish it up. So privacy, in addition to Fourth Amendment privacy right concerns, there's also a federal law called FERPA, the Family Education Rights and Privacy Act, enacted by Congress in 1974. It safeguards educational records from third parties. It allows parents, if you're under 18, to access students' educational records, caregivers, and students after age 18 to access what is considered an educational records. There are exceptions. Directory information can be released, but you have to give parents, caregivers notice, etc. Why has this been in the news recently, FERPA? Well, I get tons of questions about how it relates to AI and privacy issues. So imagine you're a teacher and you're using AI when you're creating an IEP. Or imagine a student is using AI at school and shares personal information with AI products at school, or like a guidance counselor is writing a letter of recommendation for a senior to get into college, and there's very unique circumstances around that child, or there's very unique circumstances around the student's disability, and now it's on the IEP, and now it's in AI, ChatGPT, or whatever you're using. Well, that does present some privacy concerns and issues, and maybe some issues that intersect with FERPA. So I just want to point out that the U.S. Department of Ed did release guidance in 2024 toward the end of the last administration, how school districts can help mitigate risks. I put this on here because there's just so many questions around this. So as far as, I did some digging around. The Trump administration has not rescinded this guidance, although they have put out executive orders about, we shouldn't regulate AI at the federal or the state level. But as far as I could see, it hasn't been, this particular guidance document hasn't been rescinded. And also, when I talk to school leaders, they're still relying on this guidance because it still has a lot of helpful information. So that leads me to lots of resources for those of you who are interested in AI and student privacy. There's not a lot of litigation on it. It's a gray area. So when students want to write their paper on this in my classes, I'm like, great, I'll learn something new because there is changing every day. But here are some pretty recent helpful resources for you to read about when it comes to student privacy and AI issues and FERPA and even Fourth Amendment rights and student discipline. There's a lot of intersection. So that's it for now. If this was helpful to you, come to our upcoming presentations. You can check out the Chalk and Gavel podcast that I talked about. At UW-Madison in the ELPA department, we have an education law and civil rights certificate. There's the Education Law Association. I attend every year. It's so great. Learn lots of new stuff. I attend the Martha McCarthy Education Law and Policy Institute. There are events at Indiana University. That one's free. And there's lots of resources cited throughout. So this was short. We're going to open it up to questions. But hopefully I gave you a good overview of some emerging, evolving legal developments that are not going anywhere. They're just, these cases are just going to increase in the coming days, weeks, and months. But hopefully this provided a good overview and helped increase your legal literacy. So with that, let's.
Thank you so much, Suzanne. This was amazing. And thank you all for being here on a Saturday morning. I just put Suzanne's slides in the chat, and we really hope you'll take just a few minutes to share your feedback with us because, as Stephanie shared, this is the first of our place exchange series in the educational law webinar series. We there will be two more. There'll be one. Can you flip? Thanks. There'll be one on First Amendment rights for students on February 7th, and Suzanne will be hosting that one as well. And then on March 7th, there will be yet another one under understanding special education law, exploring what's old and what's new on March 7th. And you can use that QR code or that WISC EDU to register for either or both of those. Again, they're free. And the special ed one will be led by Dr. Julie Mead, who is fantastic as well. And we hope that you'll take the time to share this with all your colleagues. Um, I shared earlier the Place slides as well, and that has the Place YouTube channel link in it where the recording for this session will be, and you can share that with all your colleagues and friends. So hopefully this really invigorated you and is sending you off on your Saturday morning with lots of zhuzh, I like to say. So thank you all for being here. Thank you, Suzanne. Thanks, Steph. Um, and, feel free to reach out if you have any questions. Have a
And,
wonderful rest of your weekend.
and thanks everyone. And thanks so much to Place again and to Sandra, Stephanie, Urel, Eric, that whole team. Thanks again.
You're welcome.